The role of the mediator is very much to act as a facilitator of conversations. Skilled mediators will help people to have discussions and gain an understanding of different points of view that they may not have had before. It's not the role of the mediator to say who's right or wrong. It's not the role of the mediator to give advice, and usually legal advisors will be present to give that sort of advice. So the skilled mediator will help parties to make decisions for themselves.
The mediator is entirely independent, and I think that's a really important point to get across. So the mediator doesn't give any advice, even if they are professionally qualified in a situation like a lawyer or an engineer or an architect or somebody who could actually perhaps give some input. That's not the role that they're taking on in that particular context. So they don't give any advice, and they certainly don't say who they consider is right or wrong. That just is not their role there. Their independence is really important. They might test some of the arguments that are being put up, challenge some of them, but they would not actually give any input in terms of advice.
What you'd hope that mediation would achieve would be that those involved would have a clear understanding of what the issues are, an ability to get under the surface and work out what's really going wrong or has caused difficulty. Then the opportunity to look forward and explore the various options which might be open to them, the pros and cons from a business, organisational and professional sense. And then, if they wish, a resolution of the matter, whether it be a contract or an employment relationship or a management issue. But resolution can embrace a whole raft of possibilities, from a new contract to the payment of some money to an agreement that separation is the way forward, and to manage that in a dignified and respectful way. Usually, at the end of mediation, the people involved will enter into a contract, especially if legal advisors are involved. That will be a way of marking what it is that they've agreed. And once they've entered into that and signed up to it, it's a legal contract like any other and enforceable in the same way that any contract would be.
If you went to mediation, the result you might hope to get would be that the matter was resolved. And if it's resolved, then the parties probably would, on the day, actually write an agreement and sign it, and that would be a binding contract in the way of any other contracts. If you didn't get to that stage, you might get heads of agreement, which again could be signed off, or a verbal agreement followed up by some sort of email exchange the next day. Even if it doesn't get to that stage, you would hope that the parties have got some sort of understanding of where they're going. And we do find that those that don't resolve on the day often resolve a few weeks down the line, because there has been some momentum built up and some understanding of where the other party's coming from.
Success rate for mediation, and we use success perhaps in inverted commas, is remarkably high, in that 80 to 90% of those matters that come to mediation tend to be resolved. I think one has to be careful about the word success, because success can mean so many things to so many people, that even if on the day of mediation those involved can't work things out and completely resolve the difficulty, very often they're able to narrow the issues, get a better understanding of where somebody else is coming from, and over a period of weeks or months thereafter, what you tend to find is that they work out a solution for themselves in any event. If mediation doesn't produce a result that the people involved need, then they can go back to other procedures, whether that's negotiating with their legal advisors or indeed going to court. Mediation is without prejudice to the ability of parties to continue with or to start a court action if that would be their default. So that, in a sense, what mediation does is offers the opportunity for people to reach an agreed solution. If not, then other approaches can be taken. I think there's a common misconception that if you go to a mediation and it doesn't produce, again in inverted commas, a successful outcome, in some way that's a waste of time or money. But the investment is always worthwhile, because what people are doing are preparing in any event for whatever comes next, carrying out the risk analyses, and very often at the end of mediation we'll have a far better understanding of where they stand and where others are coming from, and very often we'll have narrowed the issues in dispute so that whatever comes afterwards can be much better contained, both in terms of time and cost. I think in the past people have been concerned that offering mediation or taking part in mediation has been seen as something like a soft option. However, it may actually be quite a hard thing to do, because going to mediation gives you the opportunity to face up to the realities of whatever the dispute may be, also to learn from others how they see it. I think one of the attractive possibilities with mediation is that rather than having a yes, no, right, wrong result, Those involved can work in what are often complex, difficult disputes with other parties, with the help of the mediator, to find a solution that meets their interests. And often that will also enable them to find something which works for others as well, so that the solution which can be achieved is often much more sophisticated and satisfactory than the maybe binary solution offered in a court by the characterising of something as right or wrong.